Now, National Wills Week from September 16th to the 20th is a week initiated by the Law Society of South Africa to assist South Africans in drafting their last will and testament, addressing the alarming issue of 7 out of 10 adult South Africans dying without a valid will. Mpumelelo Zikalala, who's a legal practitioner at Zikalala Attorneys, joins us now to expand on this. And Mpumelelo, very good evening to you. Thank you so much for your time. I mean, drafting a will is extremely important. It's something that cannot be overlooked because not having one can present several problems for loved ones. Why is it so important?
Definitely so. Good evening to your listeners. Think about it in this manner. You work all your life, you acquire assets, and at the last stages, you do not give directions as to who you want those assets to go to at the end of the day. What's worse is that if you have kids, that individuals which are less than 18 years or lesser, then you don't make provisions to them as to who's going to take care of you, how are the assets going to be safeguarded from either your relatives or any other individuals that are there. You simply leave them hanging. So it's as if you worked all your whole life, invested a number of assets and investment into certain things, and when it comes to the last stages, you do not give directions as to how you want those assets to be distributed. Now, the will is your last word or last instructions that you give to individuals to say, for all the assets that I've worked for in my whole entire life, this is how I want those assets to be utilized. People that are going to benefit from those assets have to comply with certain provisions. For example, they would say, make sure that you're able to finish your grade 12, you're able to get a qualification. The money that I'm going to leave you is going to be able to cover for tertiary education and nothing else. If you are able to do that, then you leave a much more better grounding and a much more elevated sort of step in individuals which are going to follow from behind. So it's very important to say, when you wake up in the morning and you touch those assets, who are they going to belong to when you're no longer there? And what are those special conditions that you want them to apply for the individuals which are going to inherit them?
We've seen a lot of complications around this topic. I mean, the administration of a deceased estate can be complicated and time-consuming. What happens if one does not have a will? What role will the state play?
When the law takes over, you have a law which is called interstate succession that says, let's look at who is left. So if it's only the wife that is there with no kids or the spouse, then everything is going to go to the spouse regardless of whether there's a mkulu, a grandma, or anyone who's associated with the deceased. If there is a spouse and the kids that are there, then everything goes to the wife and kids and is distributed in a manner which is called a child share. So whichever is the greatest, the wife will get the greater share, and then the rest is going to be distributed equally in amongst the kids, whether they're from the marriage or not. And then you go in those particular phases. So the law then takes in and says, if you do not dictate to us how you want those assets to be distributed, we are going to dictate to you how those assets should be. And the danger with that is that the law does not take care of your cousins, for example, your children's sisters, or any other individuals that you would generally take care of, or any individuals which are dependent to you and have not been officially adopted by you as a person that would have deceased, which is why it's important to say, if you then decide to say, this is how I want my assets to be distributed, it must be clearly stated, so to say, in a normal responsibility way or the normal way in which I offer maintenance to any individuals, I want my assets to be distributed in the same manner. I do not want the law to decide for me. And once the law has decided, they may leave behind certain individuals that were dependent entirely upon you.
As you speak about cousins, we know that one of the hotly contested issues often results and revolves around the family house. What advice would you have for someone who wants to draft a will and has to consider the dynamics of a family house?
I think it's the individual who's drafting the will that knows best their family members and how they relate to things. And the most important thing is, if you know that there are going to be complications at the end of the day, maybe put in those provisions or statements within the will to say, I'm leaving the house to Mpumelelo because I think he's the one that can be able to take care of the house. I know that financially he's much more stable with any other individual that is there, but it doesn't mean that he's going to throw you away and put you on the streets. There's a certain provisions that you can be able to enjoy the fruits, but you must contribute to the well-being of the household. You can't stay there for free. If you're able to add provisions such as those ones, then it makes it easier even for the beneficiaries to understand the wisdom as to why you left those properties to those individuals. The one thing which is maybe a taboo and people don't want to talk about is death. And by not doing so and not making the people which are going to be left alive accustomed to it, they do not understand the wisdom as to why that particular asset was left with person A. Meanwhile, there may be a much more plausible and an important reason why it is done so. And another thing is that it's the protection of the legacy. So if you have a family home, a farm home in which all the clan or the clan will then belong to, or maybe there'll be burial grounds which are there, state that in your will as to this is what you are trying to preserve, this is what you are trying to do, and hence why you are allocating to this particular individual who's going to be able to look after it, but you may enjoy the fruits of that particular place with certain conditions that may be attached to it.
We often hear of the horror stories of deceased estates taking years to finalize and families having to wait for their inheritances for much longer than anticipated. What role does an executor play?
Well, an executor is someone who says, I'm not really involved or going to benefit personally from the administration of this estate. My job is to simply take the estate from the name that is from the person that is deceased and give it to the individuals that have been allocated. The most thing that would contribute in the estates taking so long is that they are not financed properly, which is why it's important that for you, go and get a will drafted by a legal practitioner who's going to tell you the financial implications which are associated with such, because there are financial implications that are there and they must be catered for. An example would be if you leave a house to a certain individual, there are transfer fees that must be there. There are going to be rates which are going to accrue. There may be even electricity and water charges that will be there. And without paying those fees first, there's nothing that you can be able to do. So if you engage and you go to a legal practitioner will be able to tell you and say, yes, I understand what your wishes are, but in order to implement those wishes, here are the financial obligations which are going to incur. Can the person that you are leaving this property to be able to take care of them? If the answer is no, let's take a life cover, for example, that you can be able to take care of the debts of the estate so that you're able to give your kids a debt-free assets and equip them with assets which are not going to follow any debt at a later stage. So that's why it's important for you to go to a legal practitioner, because they have a much better understanding when it comes to the administration of this estate and the cost which is associated with such.
Staying on cost, I mean, it's all very well to go to a legal practitioner and sit down to draft this will, but what about the cost implications? How much does this process cost?
Now, the drafting of the will, I do not think it would be that much of a big cost. Obviously, depending on the assets and the type of provisions that you want to insert, maybe it would be initial consultation, the drafting of the will, and then the legal practitioner will come back and give you the final product. So you're looking plus minus 3 consultations all in all. But the most important part is, are you going to be able to have those assets protected in a much more proper manner? And most importantly, the 3.5%, which is a standard fee when it comes to the administration of estates, where is it going to come from? Have I financed it properly? When it comes to things like your transfers of the house and the cars, or even the sale of shares, how is that process going to be administered? For me, I think it's the most important one rather than the drafting, because that's what causes all these estates to be blocked or to stay dormant, because individuals say, yes, I know that I'm supposed to inherit a house in place A, but I can't do so because I don't have the money for transfer fees. So it's important to go to a legal practitioner who's going to be able to explain all the financial implications, and then arrangements can be made from there. Either with the legal practitioner first to say, let me pay you bit by bit if the amount that you are charging me per hour is too big, and then let me cater for instances in which I'm no longer there. Financial instruments like your funeral cover, life cover, will then be able to cover those instances and pay for those the other costs which are associated with moving the assets from your name as a deceased to the individuals that are still alive.
And very lastly, Mpumelelo, before we let you go, why do you think so many South Africans still don't have a will? I mean, we're talking about the shocking statistic that 7 out of 10 adult South Africans die without a valid will.
I think it's a fallacy of thinking that in order for you to have a will, you must have millions of friends, you must be very rich, and there must be a number of assets in which you must distribute. I always use this example. Whatever that you touch since you're woken up since the morning up until you go to bed, that is what belongs to you. The most important question is, what do you want to happen to those assets with the time in which you die? When you have kids, then it becomes super important. Who's going to take care of those kids? How are they going to survive? How are you going to bury you? Are there any special instructions that you want to issue out so that you don't fight over your body? All those things come into play, and that's the importance of why you should have a will, so that you are able to dictate to us and tell us, these are my last words, this is how things I want to be when I'm no longer on earth. But most importantly, the financial implications associated with such, I've covered those because I don't want to inherit or bequeath you with that, but I want to give you something which is going to make you a bit richer or a step above the rest. So it's important to have a will to take care of those things.
Very well. Thank you so much for that sound advice. Mpumelelo Zikalala, legal practitioner at Zikalala Attorneys, they're expanding the importance of drafting a will as we are now on day one of National Wills Week. From the 16th to the 20th of September, we will be unpacking the different components of a will throughout the course of the week.